quick summary of Mr. Anish is that he is wondering about the dream team. He wants to have the panel members of the arbitral tribunal consisting the chairperson and other two young members. Obviously, I do have that aspiration, but okay, we can hope the best. At least in near future, you can just achieve it. It will be a reality. The second aspect of the training, not only to the arbitrators or the experts, the training has to be done to the lawyers also, so that the approach has to change to the lawyers, that it has to be a whole-time practice, not a part-time affair. Because now, having a whole-time practice with a due regard to our senior colleague, I'm saying that if we are prepared to do as a whole-time practice in arbitration, there's abundant opportunity like acting as a counsel, acting as an arbitrator, acting as an expert, guiding the technical arbitrators, and finally as a best negotiator. All these opportunities are available for us if you are sparing our whole time practice into it. And finally, his submissions on the part of institution taking role of administrative assistants. As I earlier mentioned, the role of an administrative secretary is also recognized in our Indian law. When we look on section 6, administrative assistants, it not only specifies an institution to take up the role, it is also specifying an individual. We have to seriously look upon that, particularly for young practitioners like us. We have to take that opportunity to be an administrative secretary for arbitrators as well as assisting the counsels and experts in an arbitration. Thank you. Thank you for the elaborate deliberation on the role of secretary. Now I think it's a task for me, just 5 minutes to just sum up. Before that, I like to have some question and answer from the floor so that the panelists are ready to respond.
Thank you, sir. My name is Ashish Mohan. I am a company secretary and an advocate. First of all, thank you for the wonderful session we had. It was really very good. I would like to ask one question. That is, suppose that what we have envisaged, all things happens like this, and we say all the arbitration or the institutionalization of arbitration takes place. Most of the arbitration will take place for the commercial disputes, naturally. Now, suppose this commercial disputes takes place, as we have all say 90-95% of the cases, as we have seen, let's move out of the court and happens through ADR cells. See, the award will be only known to the two parties. That is one of the features of, means award as such will be known publicly, but how it has come, the award as such would not be coming out to the others. So a company has got stakeholders. It's not just shareholders. They have got other stakeholders like bankers, including the government, including the public, because he's putting up factory or industry in my place, that is my land as an Indian citizen. And don't you think it should be disclosed? Another aspect is, say in the next 20-30 years only, as we have seen that it moves out to the court and only happens through ADR. What happens to the law students? They will study only 30 years old law. They will not be aware what is happening in the commercial aspect, especially in companies that when we talk about corporate governance and all. So recent example is the Tata versus Mistry case. Just imagine if it has gone to ADR, nothing would come out. At least we are aware that what is happening in NCLT and what all decisions have come out. So my only question is, don't you think one fundamental thing at this point we are making, one biggest mistake is, arbitration is good, ADR is good. But don't you think that we should disclose the entire award, how the award has come? Because that would lead a lot of other agencies to come out of it. Thank you.
The issue raised by you also was echoed by, I would say it was raised by Chief Justice of UK last year in one of the conferences, where he said that this arbitration is really coming in the way of development of jurisprudence English jurisprudence, and it really raised a lot of debate all across the globe in international arbitration circuit. Answer to this is that now more and more arbitration awards are coming in public domain, though it is masked. You have certain institutions involved, like in South Africa, as per the Act, any arbitral dispute where government is one of the parties, those whole proceedings and awards are not confidential, and there has to be transparency. Now, you have BITs again giving you that. But so far as confidentiality aspect is concerned, it is being taken care of. Even the Singapore judgments of Singapore courts are being masked, and they are coming out with this. ICC is coming out with this in a big way. And I think this is the confidentiality issue I have to say with.
The one more just to add to that is that, see, arbitration is like a civil suit, and we don't have the decrees reported in there. And what ICC has started doing is, as Mr. Singh said, is remove the names, because the whole virtue of arbitration is confidentiality. So you can have as for development of law, you can have those awards. As far as the disclosure to the public is concerned, if it is required under any other law, they will have to do it in any case, because if they are a listed company, the listing agreement itself will require disclosure of the pending matters and all. So overall, the larger public interest is taken care of, because the virtue of arbitration is confidentiality, and especially when you have cross-border, you would definitely want to keep it confidential, because many things get discussed, numbers get discussed in arbitration, which ultimately is not required for any public knowledge.
I think adding to what you asked, I think you want to know why there should not be more transparency as regards the awards. As you find in any case which has been adjudicated upon by the court, we get to know it. In the newspapers, we get to know it in the law reports. The difficulty here is, in India as it is, you find it is ad hoc arbitration going on. So there is no question of somebody getting at the particular arbitration award to be reported. This is where I would stress the point that if we have regional arbitration centers with the backing of law, all these awards will be open. Reporters will get opportunities to look into. Some of the awards will be wonderful pieces of judicial pronouncements. That can be, there should be. Once it develops, there will be reporters who will be reporting arbitration law, which will be useful for others also. Privacy is there, I do concede. But at the same time, every litigant is supposed to have his privacy. But look at his cases coming up and being discussed everywhere. So, of course, that part can be taken care of. But at the same time, it's a valid point which you raised. One should know what is happening in that particular company. That's right, absolutely right.
Yeah.
Answer to the gentleman's question was, his bigger worry is what happens where there are other stakeholders other than the parties, how to go about this. Please appreciate, any decision of any tribunal which will be in the nature of decision in rem is not arbitrable. Therefore, in fact, you can refer to Ellen Booth judgment, SBI Home Finance Ellen Booth judgment of Justice Ravindra. It may have its own criticism, but this is one judgment you can refer to that will give you an answer. To answer your query, please appreciate, on the one hand, one of the reasons why we are wanting to shift towards arbitration is excessive case load on the courts, the judicial system. When you go towards this particular system, which is an alternate system or appropriate system, whatever we call it, it will have its own consequences. That is one. Two, nobody stops the parties to arbitration agreement from agreeing to have transparency. In fact, confidentiality and transparency are two different concepts having different connotations. Three, Whenever we talk about presidential value, in fact, this is obviously a global debate, you know this. However, let us talk about exit awards. These are being taken as guiding awards on principles which those awards are discussing. I can give you my example. In many domestic arbitration, I have referred to exit awards, and arbitrators are taking with all seriousness. Now, question is, an exit awards, or for that matter, investment awards, you have plethora of awards and decisions, even interim orders are coming in public domain. Now, question is, you have to take a policy decision whether we want courts to dispense with justice with overloaded docket, or you want to move toward others where you have other options as well. Thank you very much.
Now, first regarding your question on mediation on family disputes. See, that is a misconception because family disputes are purely on relationships, and mediation also harps on maintaining the relationship. So I don't think there is any dispute which is commercial or between two or business disputes where they don't care about relationship. Any dispute or any disputants which care about their future relationship will opt for mediation, because mediation takes care of that. Since family dispute, we are more familiar about relationships, we are talking about mediation in family disputes, but it is equally applicable to commercial disputes. And in international commercial matters, that is the first option now. Regarding your second question, I think it's very clear now, because the that is why people prefer institutional arbitration. Institutional arbitration has as a pattern of their own institutional arbitration clause, which prescribes that in case of dispute, the parties refer to arbitration. And even Section 11 provides for such a provision, where in Section 11(6) you say the institution doesn't appoint an arbitrator within such and such time. Only then the Chief Justice or the High Court or the Supreme Court will get jurisdiction. So it is already protected.
And just to add to that, even though you don't have the institutional arbitration in your contract, the court itself under 11 can delegate the power to the institution. And there was a big debate whether the court can delegate a judicial power. So the law says that the delegation of power to appoint will not be a delegation of judicial power. So that ability is given under the law itself to the court to delegate the appointment process to the arbitral institution.
I'll give you one example to conclude on this question. There was an arbitration clause written between one Indian party and Japanese party. Arbitration clause said whenever dispute will arise, if Japanese will have to invoke arbitration, arbitration will happen under the rules of India International Arbitration Center. If Indian party will have to invoke arbitration, it will happen Japan International Arbitration Center. Disputes arose. The Japanese started to find out where this India International Arbitration Center is, which was nowhere to be found. Ultimately, this matter went to Supreme Court of India. I was representing one of the parties, and then the other side came out with a fantastic proposal. They said, why can't we have a retired Supreme Court judge as an arbitrator? To that my answer was, whether it is a case of pathological arbitration clause, which means badly written arbitration clause, we have to see the intention of the parties. They wanted institutional arbitration, though they have written something which they never wanted to write, and Supreme Court of India agreed with me, and we had that CIIA arbitration which we ultimately won. Thank you very much.
Just one word to some of this entire panel discussion. We all Indians, we have a tradition of arranged marriage. Arbitration, institutional arbitration is like arranged marriage. Don't opt for choice-based marriage. Go for arranged marriage with horoscope. That is an effective institutional arbitration. Thank you all for patiently hearing all of us.
Thank you, moderator and resource persons. It was a very fruitful venture. And now we have time, and it is now my responsibility and the team's responsibility to provide, as a token of our gratitude, as a token of our love, a memento from our part to the honorable delegates. So,